right, so now I have to be careful what I say. No, I'm always careful what I say, right? Okay, so today's fun is on our NVAR contract updates. And we have 24 documents that are being updated on July 1st. And I will take credit for some of the updates that are happening, and I will not take credit for others. And as we go through, I will tell you which ones I take credit for and which ones maybe some of you should take credit for, and which ones our friends in Richmond are causing us a little bit of fun on. So with that said, I am going to share my screen. If you have questions as we're going through, I probably won't be able to see you because I'm sharing my screen. I definitely won't be able to see the chat. So just ask as we're going through. If it's something specific to a specific situation that you have, write down your question and hold it until I give a break for questions. If it's that I went too fast and you have no idea what I just said, interrupt me and let me explain it again. There are a couple of the updates that are pretty big updates. So I want to make sure everybody understands those. And I will point out a couple of things that I'm going to talk about that might not make full sense until we get to another piece. Okay, so I will point those out along the way as well. Okay. Does everybody have the packet? Do I need to put it in the chat again? Maybe I should just put it in the chat again real quick before we get started, and then we will go from there. Okay, there is the packet. The cover sheet on the packet is the list of all of the changes. We're not going through every single document. I will just share with you a couple of the things on the documents that we are not going to go over today. Okay, so bear with me 1 second, and I'm going to make sure that I have the documents up properly before I share my screen. And we'll get started. Does anybody have questions before we get started? No? Okay, awesome. One thing I would like to say before we get started is that if you have started a room in DocuSign and you have added any of these documents today in DocuSign, they will not automatically update in your room in DocuSign. On July 1st, these documents will magically update in your forms libraries, but they will not update in your room, okay? So if you have a client who you are working with right now and making offers for right now, and you need to make another offer for them after July 1st, this is the only time that you are able to delete a document. And what you do is you delete the form from the room, and then you go into the forms library and add it back in, and then it will be the new version, okay? I know that one of the shortcuts that I suggest is to bring in your contract documents when you have the buyer agency agreement signed and start to prep some things that don't change. And that is still a good thing to do. It's just not the best idea to do if you sign a buyer in the last couple of weeks of June or the last couple of weeks of December, because then we're going to have forms updates. So you don't want to start prepping documents that are going to change. Okay, so just to recap, forms libraries magically will be updated July 1st. Your room will not. So if the document is in the room, you have to delete it. You can only delete forms. So you delete the form with the blue icon at the bottom, and then you go into your forms library and add the document back in, and it will be the new version. Okay. All right, let's get started. Can everyone see my screen? Okay, you see the cover sheet? Awesome. All right, so you guys have the full cover sheet, which is what was presented to the NVAR Board of Directors. So what happens is the committee works. We have once a month meetings and sometimes subcommittees where we go through things that we think would be helpful to agents, to brokers, to the public, to update the documents to make sure that everybody understands what the expectations are and the rules and the laws and things that have changed. We then compile the documents, and the chair and vice chair go to the board meeting and present to the board of directors and say, hey, this is what we think would be best. And the board of directors gets to say yes or no. Most of the time they say yes. Sometimes they say, can we tweak this? Can we add this? Can we take this out? And sometimes they say, go back to the drawing board. So we're going to go over some things here that mostly were just approved. A couple of things were added by the board, but this is what we have to work with for July 1st. Okay. So I'm going to come back to this. This is just for your knowledge. I have this cheat sheet for us to go through as we look at the documents. Okay, so the first document that changed was our residential sales contract. So the residential sales contract has a couple of things on it that we updated, and page 1 did not update. And page 2 did not update, but I thought it was best to print the whole contract for you so that you could just have a visual. The first thing that actually changed for you is going to be on page 3. And it's right here where it says buyer's notice to seller. Okay, this is where you put the settlement agent that the buyer selects, or where, if you're the listing agent, you see who the buyer has selected as the settlement agent. Now, why is this here? Why was this a change? It used to just say notice to seller, and we updated it to say buyer's notice to seller because we are still seeing many contracts come through across the board that have some notation somewhere about who the seller is using to close with. And who the seller is using to close with is not relevant to the contract. We don't want to see it anywhere. This section right here is actually not a negotiable part of the real estate contract. It is a notice. All right, notices are information from the buyer to the seller, or the seller to the buyer. So this is not negotiable. This is a right that the buyer has to tell the seller something that is given to them by the law in Virginia. And we added it to say buyer's notice because we wanted another talking point for training purposes so that we can try to get the realtor public to stop writing in the margins here or above here or somewhere who the seller is closing with. In most cases, when somebody writes in who the seller is closing with, they even write in something that's not enforceable because there can only be one settlement agent, one settlement company in a transaction. So what will happen is the agent will write seller selects universal title, right? If the buyer selected ABC title, then we would say seller selects universal title. Well, that's not accurate. The seller can choose the Mason law firm, which is the law firm that is associated with universal title, but they can't select universal title because there can only be one settlement agent. So again, it doesn't matter who the seller is using. You don't even have to send a formal notice on paper with who the seller is using. The buyer can tell, the buyer settlement agent can be told by the seller side when they reach out after the file's open, who they're closing with. It can be an email. It just doesn't have to be anything formal, okay? So that is that. Now the next change is a little more intense. It's a little more detailed, and it has to do with HOAs and condos. Okay. This change is number 8, where it says Virginia Resale Disclosure Act. Our current contract has Virginia Property Owners Association Act as one paragraph, and then another paragraph that says the Virginia Condominium Act. Now, our friends in Richmond had a good idea that has a couple of consequences that aren't so great that they're going to have to clean up when they reconvene in January. But I'll tell you the good things first. The good thing is we got to get rid of an entire paragraph on the contract, because the resale disclosure requirements for condos and the resale disclosure requirements for HOAs are the same. So instead of having 2 separate paragraphs and 2 separate sets of rules that were identical, they updated the law so that it's just one set of rules that covers both. And so we were able to put that in one paragraph, okay? Nothing has changed about the review period when it comes to having 3 days after delivery of those HOA docs or condo docs for a buyer to void, or extension up to 7 days if agreed. There's nothing that has changed from the fact that a buyer can void before they get them, right? It's up until 3 days after receipt. If they have 2 separate associations, so if it's a condo that's also in an HOA, so there's 2 different associations, that rescission period, that review period, goes up until 3 days after receipt of the last set of documents. Okay, all of that's the same. What's different now is they're calling the resale disclosure package, right, the HOA docs, they're calling it a resale certificate. And that's a little confusing, because when we think certificate, we're thinking that it's like a piece of paper, right, or a document, but it is still the whole package. They have not yet addressed the requirement for it to be complete, to be considered delivered. So incomplete documents, the buyer's sole remedy is still to void. Okay, if it's incomplete, it's still considered delivered. Another change that they made to this is that the buyers, the sellers right now have the ability to pay at closing for these documents. Okay, so they get ordered through the HOA, and the HOA or condo association has to give the choice. It's required that they're given the choice to pay for these HOA docs at closing on the settlement statement. Effective July 1st, the associations are no longer required to give that option. So what does that mean? That means for all of us that offer as a service to our clients that we are going to order the HOA docs for them, we have to pay for them up front if the HOA requires it. Now, we don't know which HOAs and condo associations are going to actually enforce that. Some may still allow it to be paid at closing, and paid at closing is really like a 90-day grace period is what they were allowing, and then it just gets tacked onto their assessment. It's not, you know, a forever delay. It's 90 days. So a couple of things that I will point out on that. That is a reimbursement for an expense if your seller allows you to pay for it on their behalf. It is a reimbursement that you may be paid directly. Okay, they can reimburse you directly for that. Does not have to go through a market center. Also, on the ALTA statement, you can be reimbursed. So you can be reimbursed at closing, and the title company can pay you directly. It does not have to go through the office like your commission does. So it would go on as a reimbursement with your name, and the title company would pay you directly for that. Okay, so you don't have to worry about, if you forgot to turn in your paperwork and your commission is paid late, you at least get the reimbursement from the title company for the HOA docs that you paid. You also can just change the way that you do it and have your clients order them. Okay, that is up to you. The second thing that may not be so great, that will be fixed in January, my crystal ball that's up on my shelf tells me, is that in the statute as it sits today, there is explicit language that says the buyer may not waive their right to the review period and cancellation. They just may not. When this was updated and everything was meshed together into one set of rules, they forgot to bring that line in. Okay, so it doesn't explicitly say that the buyer may not waive their right to the review period. It still says that the seller must deliver the resale package. There is still a requirement that the seller take care of any violations, right? And after closing, that still survives closing. So if there are violations and the buyer goes to closing and the buyer has to remedy them, the buyer could go to court to try to be reimbursed because that survives closing, because it's considered a lien against the property. So what we anticipate happening are buyers trying to waive their cancellation period, right? Their right to review the HOA docs to try to make an offer stronger. That does not take away the seller's responsibility that they have to deliver the documents. So they don't get to save money by not delivering the documents. They don't get to save time and energy by not taking care of the violations. Okay, so this doesn't actually make an offer stronger. It makes things complicated, right? And in January, when the legislature comes back in and is like, holy cow, I can't believe we missed it, which they're already saying, holy cow, I can't believe we missed it, and they fix it, anybody who got out of the habit of just making sure that this was done is going to have to then relearn how to do it how we've always done it. So what we're all hoping, the attorneys at NVAR, we've talked about this, what we're all hoping is that we just continue to do business the way we've done business, right? So that we advise our sellers that that's not a good idea, and that the buyers just understand that they just need to know what the docs say, right? Don't use them as that get out of jail free card to bully the sellers right now in this market, okay? Any questions on this? Because there are big changes in this. Okay. The next section that we have updated is going to be to personal property and fixtures. Okay, so that is going to be this paragraph right here with some pre-printed language. How many of you have heard of these weird things on roofs called solar panels? Anybody heard of those? Okay, awesome. So we in Virginia, I guess, had been thinking that solar panels weren't actually going to make their way to Virginia. They've been pretty popular in Maryland, and in Virginia, we just thought they weren't going to make it here. But they're here. And so we have dug in to having actual documents that you can use for solar panels. And where it starts is here in the personal property and fixture section. And right here in this automatic part where we talk about things that do convey and do not convey, we've added electric vehicle charging stations and solar panels. So solar panels, if they are installed on the property, there is an addendum. Okay, we have an addendum to the sales contract and an addendum to the listing agreement that we're going to talk about, and it's in your packet. Okay, electric vehicle charging stations were something that we added in as well, because those are hardwired into the property. They're expensive. Some sellers want to take them and have them reinstalled in their new property, and they're hardwired into the property. And so there's a huge risk that if a seller tries to take that, it's not going to be uninstalled properly. It's not going to be capped off right because of all of the electricity and the separate line that has to be run. So we are saying it's installed, it's a fixture. Okay, those items automatically convey. So we added those there. And we will talk about solar panels a little bit more as we get through this document. Okay. And then along with solar panels, we did add to this last page right here, just the checkbox so that we could indicate that that solar panel addendum is attached to the contract. Okay.
Shannon?
And yes.
It seems like a contradiction there. It says that the solar panels and the car charging stuff conveys, and then the next sentence says surface mounted or wall mounted electronic components do not convey, right? That seems a little inconsistent. It seems like a little great confusion there.
So surface mounted, that is like talking about like speakers and TVs and things like that. So the wall mount, the brackets and the mounts convey, but the things that are attached to that don't convey.
That makes sense to say it, but it's not very clear to me from this. I think this is poorly worded.
I think that, let me go back to that paragraph.
I think this is going to create a lot of confusion with these two sentences.
So surface and wall mounted are not installed, and they're not actually connected to the property like a fixture is. So surface and wall mounted means you just like pop it off, right? It's not actually electric, you know. I'm trying to think how I describe it best to you so that you're not going to come back at me and it has to be like hardwired into the property to automatically convey. And a surface mounted component is not hardwired into the property the way an electric vehicle charging station is, or
okay. That makes a lot of sense, but that's not clear in the wording that they have in here.
I'll take that back to the attorneys, but I think it is, because it says surface mounted instead of hardwired, right? So we'll but we'll talk about it. Yeah.
Shannon, I gotta just something to add to that. So it sounds like the EV charger, for example, a Tesla, you can order it comes in the mail, can be taken off, but the electric stays. All the wiring and that outlet, that special outlet stays where it is, but you can take your own charger off because it is wall mounted into that electric that you had wired.
So the whole thing here, the whole charging station is what conveys. We don't, the point with this is that we don't want anything unhooked, anything uninstalled. Now, if the buyers and sellers agree in writing that something is going to be different, then that's fine. There's nothing that prevents them from having specific agreement on it. And the automatic conveyance is that the whole charging station conveys.
Okay. Yeah. All right. Because Tesla's got their own, although that's going to be changing.
Right, because the new ones are, you know, they're trying to make them universal.
And mine isn't, you know what I mean? So I get it. Okay, so if I sell my house, I'll leave all the electrical that we did to get that charging. It's not really a charging station as much as a thing that plugs into the electrical that we installed, you know what I mean?
Right,
So
right.
we just write something additional.
correct.
Okay, thanks.
And again, these are new things that we're putting in that were never there before, right? So we have to start somewhere so that there's an expectation. So it's at least spoken about between buyers and sellers so that they know what's happening in the contract instead of it being completely ambiguous. Okay. So that's it on this document. Okay, any other questions before we go on to the next one? All right.
Shannon,
Yes.
sorry, I'm late to hear. I think we'll get into it on the solar panel addendum, but I have some extra questions on that one. You
Yeah,
think we'll
so-
get into it on the addendum?
Well, I'm sure because all it says here is that solar panels convey. So we have a solar panel addendum and a solar panel listing amendment. So there's 4 more pages of
Oh,
information
that's
on solar
exciting.
panels. Yeah. So
My
I have a feeling.
favorite topic.
Yes. Yeah.
Not.
Yeah. So hold all questions related to solar panels until we get through those documents, and then we may have very well covered it. Awesome. Okay, so I know I started off by saying we have 24 documents that changed, and the change I'm going to tell you about right now is actually covered in 5 of those documents. Okay, so we made a technical change that I don't think anybody would know about, even my STAR students. Probably wouldn't see this yesterday. I taught this in Kingstown in person and I had more than 20 people in the room and nobody was able to see it, and it's okay, it doesn't hurt my feelings. On the appraisal contingency sections or appraisal sections in a lot of our documents, the financing contingencies, we had some verbiage that said that the contract is or is not contingent on appraisal. But we also have a box that says that you check if it is a contingent on appraisal or is not contingent on appraisal. So there was just some redundant language in this paragraph that we got rid of, right? Because you don't have separate appraisal contingencies. It's automatically included in VA, FHA, USDA. We cleaned up the language here on conventional financing and the appraisal no financing contingency, right? The one that you would use if your client's paying cash but wants an appraisal. So we cleaned it up on all of those so that you don't actually check the box to say it's not contingent when this is the box that would just be left blank if it's not contingent. The other thing we did on the appraisal no financing was that we fixed some of the language related to the appraisal gap that wasn't consistent with the conventional financing addendum. So that's cleaned up. Again, nobody would really notice because you don't use it much and you expect it to look just like this document. Okay. So that's 5 documents. Now we have the solar panel contingency addendum to the sales contract. Now I still believe that there will be questions after this document, and we have the listing amendment document to go over later in class. So some of those questions will still be answered, and I'll try to preempt some of those on this document. So as I mentioned a couple of minutes ago, we started from nothing, right? We had given our agents nothing and said, figure it out. Okay, so this is much better than nothing, in my opinion. And we have a subcommittee that's going to be working on this further for the second half of the year so that we can try to tighten it up a little bit and see what we miss and have an updated version for January that hits the things that we missed, that we didn't quite know about, even though we did work on this for several months before rolling it out for July. The basis for this document is that we want a buyer to have the right to review documents related to the solar panel system and any financial documents that are necessary. We want them to have a review period. Okay, it's just like the HOA doc review period. They get to review it, and if they don't like it, they have a get out of jail free card and they get to void the contract. Okay. With our listing amendment document, these documents are supposed to be gathered at the time of listing. So they should be ready to be provided at the time of ratification. These are not documents that a seller should be gathering after the contract is ratified. They should be gathered right away. The seller is disclosing whether they have outright ownership of the panel. So there's no lease or anything on it. They don't have a loan to pay off. They don't have a lease. There's no other agreements on it. It's owned outright. Then there is a second section where they say there's a loan or they have a power purchase agreement in place, something that is monetary, that is a lien that's going to have to be turned over. I've already made notes that we may want to add a separate section for what happens if it's not owned outright, but it's going to be paid off at closing. We may want to clarify that a little bit better. But for now, these are the two choices. In both choices, the buyer gets this review period, okay? And it says that the buyer has a certain number of days to review the documents, okay? They get to review the documents. And if they don't like what they see, they void. So by 9 p.m., blank days following the date of ratification, the seller has to give the documents. And then after they get the documents, they have a certain number of days to review the documents and move forward or void. These are negotiable numbers of days, okay? If the seller already knows that they're waiting on some document from somebody, then they might need to say, I need 7 days before I can give you the documents. But if they have them, then you negotiate that it's within 3 days or 2 days or whatever. If it's a buyer who's had solar panels before and is very familiar with them, they only might need 3 days to review the documents. But if they've never had solar panels before, they might need 7 days to review the documents. So this is a negotiated period of time. We also have a period of time where the buyer can get financing, okay? So they have to assume the loan. They're going to apply to take on the loan, whether it's the lease or the loan from the creditor or whatever the case is, okay? There is a period of time for them to do that. And then here's the information for the payments that's listed in the listing with the documents, okay? So this has to be disclosed in the listing, and I'll show you how that's done. So it's part of the contract, right? This information. If the buyer is declined for taking over the lease or taking over the loan from the creditor, right, to assume that loan, then the contract can be void, or they can renegotiate that the seller is going to pay it off, right? So this is your basic contingency. Here's something I'd like to say. If your buyer is getting a loan, if they are doing financing, do not allow them to waive their financing contingency. Everyone here knows that I do not want you to allow your clients to waive their financing contingency anyway, right? It is one of my many soapbox moments. Do not let them waive their financing contingency, because what we're doing here is we're saying, hey, you actually can go apply for a new line of credit after you ratify, right? when we are trained to tell them, do not apply for anything after you have ratified because you need to get this mortgage. But in this case, with solar panels, they actually have to apply for credit, right? They have to be credit worthy with the creditor, with the lender for the solar panels. So protect your clients. If they're able to afford the house, they probably can afford the solar panels, and it's probably not an issue. And when it's an issue, it's going to be an issue. So if your client's right on the line and their debt to income ratio is a little close, or their credit score was a little close, and they had been working really hard to get their credit score up somewhere, and then they go and have their credit pulled, and then it affects their score, you don't want that to happen, right? So talk to the lender, make sure that everything is smooth, right? And make sure it's not going to be an issue to have that credit pulled, and keep that financing contingency in place. And if a listing agent says anything about it, tell them they're the ones that are asking for your client to go have credit pulled after the ratification. It's their seller that's asking for it to happen. So remind them, right? And then it should be fine. But just remember to protect them on that. Okay. I'm going to ask, is there a question about something I explained, not about something that might be missing from that document? Okay, am I going too fast? If we do this right, you won't have to listen to me for the full 2 hours. So I'm trying not to go too fast, and I know how much all of you love listening to me yap, but 2 hours is a long time.
So I know you asked if there's questions about what you explained versus something that might be missing.
Yes.
So let me know when you're ready for that.
Okay, I will, as soon as we do the amendment to the listing agreement, then I will take all of the what did we miss questions.
Gotcha.
And maybe I'll have you be a guest on our subcommittee. Okay, the next document I'm going to show you is the lease. And the lease, if you printed this packet and can look also at the pet addendum at the same time. I can't do that, but if you can, this will make a little bit more sense to you. I'll scroll to the pet addendum and then I'll come back to this. So in January, we had a major overhaul of the lease, okay? And we gave you this, the box that had the rent and the money and the security deposit and all of the things that were money related, to try to clean it up and to make it a little clearer than that weird paragraph that everybody messed up about the prorated rent, the total rent for the lease term, and all of these crazy things. And I'm hoping that everybody loves the box that we gave you in January. And we added a couple of things to it. And one of the things that we added to it is actually from the pet addendum. So I'm moving ahead to the pet addendum. When landlords wanted to charge a pet fee at move-in instead of a deposit, so they were charging a fee that they were just keeping, it would be written in this additional security deposit place on the pet addendum, and it would say something weird like non-refundable pet deposit. And those of you that have heard me talk about deposits know that there's no such thing as a non-refundable deposit. By definition, there is no such thing as a non-refundable deposit. So this is one of the things that our membership can take credit for on the change, because I couldn't stand it anymore to see non-refundable pet deposit written. So we added the additional fee. So any landlord that wants to charge that non-refundable pet fee can do it properly here. And if they're charging a pet deposit that is refundable, then it goes up here in this additional security deposit. Now, I just want to remind everybody who does leases, this additional pet deposit falls under the rules of security deposits. So if your landlord is collecting 2 months rent as a security deposit, they cannot collect an additional pet deposit. Okay, the maximum amount that can be collected is 2 months rent. So keep that in mind if they're trying to collect a pet deposit. Now I'm going to go back up here and we're going to look at this little box. And it says now non-refundable pet fee, if applicable, and see pet addendum. Okay, who's it paid to? Same thing. And other fees, if applicable. So these are like move-in fees. So sometimes condo associations require the tenants to pay to use the elevator, right? Anything like this would go here. This is the catch-all, so that it's agreed to upfront, it's clear, everybody knows what has to be paid, who it gets paid to. We also clarified that rent includes administrative fees, pet rent, utilities, or other charges that may be agreed upon. This is for the purpose of being able to go to court if the tenant stops paying things that they've agreed to. So if utilities are included in the rent, or a landlord is charging pet rent, which I think is the dumbest thing ever, just up the monthly rent and call it a day. Any of those things. So this is for the purpose of being able to add that if the tenant stops paying their rent and you have to go to court. Okay. Any questions about the change on the lease or the pet addendum? Oh, the other administrative thing we did, we added the extra landlord signature lines because it was very confusing for some people because it only had one landlord line instead of enough for all of the owners to sign. So it got very confusing. So we just fixed that. Okay. All right. Questions on that? Okay. Understanding your rights under the Resale Disclosure Act. I included this to highlight that I would love for all of you to read this because of the changes that came out. I'm not reading it to you, but it changed significantly and it may be worth using for the first couple of months after the forms changes until everybody's used to the fact that it changed, but we're not going to read it. It just had to change because of the new rules. All right. Because we were talking about solar panels, let's go ahead and talk about solar panels. This is in your packet next, and it's not my packet, so bear with me. Okay, so solar panel addendum to the listing agreement. So there's a couple of things with this. The first thing I want to point out on this is that we have a document that's called the optional listing information sheet that the listing side should be adding to Bright MLS, right? It has the conveyances, it has where delivery is supposed to be made, does FERPTA apply, like all of those things, right? Every listing agent should be using this. The past president of NVAR was requested that we make it not optional, right? Because everybody should be using it. And we thought that adding all of the solar panel information to that document was going to make it too long. So we added language to this addendum to the listing agreement so that if solar panels apply, that this document also becomes an addition to that optional listing information sheet, instead of having a whole bunch of unused information on that document, right? Because it would just be too long and unnecessary, okay? So a couple of things to note. It says right here that this addendum will be included with the optional information sheet, and any documents that are attached to this, because from the listing side, we're asking the seller to provide us copies of all of the financial documents, the documents on how to take care of the solar panel, like everything, right? We're asking them to give it to us, but we're not giving that at the time of listing to the public. We're saying that any documents attached for the listing purposes and the agreement with KW will be provided to the buyer pursuant to the ratified contract. Okay, so we're just trying to clarify that we're not putting that all in the MLS, because there's personal information when there's a lien or a lease or anything like that. We don't need to give all that information. So this document is similar to the addendum to the contract, and it talks about what it is that is conveying, right? It's we call it a solar energy collection device, right? Solar panels. Now, my caveat here is this. We are very aware that there are other systems that are coming out every day. There's new technology coming out. The newest thing that I had heard of are the shingles. Okay, the solar shingles. We, as a committee, did not have enough information about the solar shingles or any other of this technology, and the way that the ownership works and the way that it conveys and those things, to put that here in this document or any of the other documents. We are focusing right now on solar panels because that's what we have enough experience with to put something together that we can stand behind and we can train and we can explain. This document will likely evolve into something that will cover all of those things over time, but we just don't have enough information on that. The title attorneys in our committee have been working on this, when it comes to closings for a while, when it comes to solar panels. So they know what those documents look like. They know how to record and release the liens. They knew all of that. We have agents that have worked on properties that have the solar panels. Like, there's different things that we had enough experience with that we could put something together that we could stand behind. So know that we're aware there's other things, and as we have enough information, we will provide that. Okay. So this is where the seller also tells us what the ownership status is. Do they own it free and clear, or is it subject to something, right? Is it subject to some sort of lien? Is it financed? Is there a power purchase agreement? Is there a lease? What's the deal, right? And if it's financed, are they going to buy it out and prepay the remainder, or are they going to ask the buyer to take over the loan? Okay, and what's the information? Because we have to provide that. So there was a space on the second page of that addendum to the sales contract that asked for payments and lender and all of that information. The buyer's agent would get that information for the offer right here, because this document is to be providing to the buyer side before the offer is put together. The transfer fee is supposed to be disclosed, and who is going to pay it? Okay, is the seller going to pay the transfer fee, or is the buyer going to pay the transfer fee? Are there other fees, right? So maybe they have a loan and a power purchase agreement, right? Like, so there could be multiple things. They have to tell us about that up front. Okay, and then all documents pertaining to the system that's in their possession need to be provided to us And then that way we know that they have it ready when we ratify. Okay. All right, Alicia.
First time on Zoom. Sorry. Everything looks good. The only thing I would have a question about is if we are in a situation where the buyer is wondering if the solar panels are working, does that fall under the home inspection if they have a home inspection, or would that be separate?
Yep, great question. So inspections cover all inspections that are not listed as separate contingencies in the contract. So you have well and septic inspection that's listed separately in the contract. You have radon inspection that's listed separately in the contract. Every other inspection falls into the home inspection contingency period, where you get to line up all of your inspections in that time period.
Okay, gotcha.
Great question.
Thank you.
That's it? That's all we missed so far?
Well, you covered it. You covered it. And really the only thing that can be, it's all there, but the only thing that can be kind of tricky is the different kinds of companies have different rules.
Mm-hmm.
And so it's here where you have to do your research, and it's what I've learned in the listing. If you had not gone over that, it's where you really get in trouble.
Yeah.
And so I appreciate that this is in the listing now, to where it reminds us, let's ask this.
Yeah.
Listing agreement.
Perfect. All right. Anyone else with questions related to the solar panels? All right, so we're going to go on to the agency agreements next. All right. Exclusive right to sell listing agreement should be the next fun thing that we're going to review. So there's a couple of significant changes on here that I hope make your life easier and clearer and better. So these agreements that we enter into have to have a couple of things to make them enforceable. And we wanted it to be much clearer for agents, brokers, clients on a few of these things. So when we look at a listing agreement, a tenant agreement, a buyer agreement, something for land, right? We're looking for key elements. We're looking for the term of the agreement, right? We're looking for, if it's a listing, we're looking for a price, a list price. We're looking for compensation. We're looking for on the market date if it's a listing. Of course, we're looking for signatures. We have to have key elements for it to be a valid contract. So our rules in Virginia state that if you do not have an end date that is mutually agreed upon in an agency relationship, that it automatically expires after 90 days. So as we look at what's happened with some of these agreements over time, and I know none of you would ever leave something blank on one of these documents, because you just wouldn't, because you've had to come through all of my trainings and you know if there's a blank, you have to fill it in, right? But sometimes there's a situation where it's left blank accidentally, but really there is an end date. So if everything else is filled in, then your agreement still is valid, okay? So what we did was we added to this that if left blank on the termination period, that the agreement automatically terminates after 90 days. So if you fill this in, nobody's ever going to see that language. So it's not like we're suggesting that it expires after 90 days. It's just if it's left blank, because there had been confusion on, do we actually have an agreement? Do we not have an agreement? When does it terminate? So we put in what the law actually says. Doesn't change anything. It was always 90 days. We just put it in. Okay. The conveyance sections of all of our documents that say conveyances have been updated to show the solar panels and the EV stations. The next significant change here is our compensation section. Okay, now this section was actually prompted by the buyer agency agreements. Okay, the buyer agency agreements have over time raised my blood pressure, made me laugh, made me cry, all of the above on things that I have seen written in. Sometimes they're stories that are written. Sometimes they are very clear what's written, and other times agents think that they're clear and they're just not clear on what's written. So this was something that, because of the change that we needed to make on the buyer agreements, we decided that obviously it had to look similar throughout, and hence the change on the listing agreement. It may look very confusing to you at first because of the choices. And what I will say is, for the most part, this isn't going to affect you very much with the other choices. Every brokerage has a different model. And so we had to make sure that we were covering every model that was there. On listings, for the most part, our agents do a percentage of the gross sale price. So that's going to be this section right here. Okay, you would check the box and the compensation would be a percent of the gross sale price. Okay. If you were charging a flat dollar amount, then you would go here and it would check the box and it would be a flat dollar amount. There are some brokerages that, this is more of the discount brokerages, that do a percentage on the listing side. I'm sorry, they do a percentage that they offer out to the tenant's agent or buyer's agent, and then a flat fee that they keep on the listing side. Okay, so this is how they would write that, because the total has to go up in the top, and then out of the total down here in this cooperating broker section, this is where you would write how much you are giving out to the buyer side, or if this was a lease listing, to the tenant side. So for your purposes, you would be putting in your percentage, the total here, and then the percentage down here that you're offering out to the buyer side, or if this is a lease listing, to the tenant side. Okay. And it's not going to say gross sale price, it would say month's rent on the tenant side. So as an example, if you're charging 10% of the gross sale price as the total, right, it would go here. You check this box and put 10%. Nothing would go in these boxes. And then you would come down here to buyer agency compensation and check this first box right here. And if you were offering 5% to the buyer's agent, you would put 5% of gross sale price and nothing in the rest of these boxes. Okay, again, for the most part, for the KW United agents, you're not going to use any of these other boxes. But what might happen for a discount brokerage is they might say, we're going to offer 5% of the gross sale price to the buyer's agent, and then we only keep $100 on the listing side. Okay, so they have to do 5% plus $100. And then down here, they would say, check this first box and put 5%, because that's what they're offering out to the buyer's agent. Okay. The rest of this pre-printed language here did not change. It's simply a way to clarify and give the different options of how the commission can be calculated so that it's actually clear and enforceable. Now, agents who charge what I have been referring to the last couple of days to as admin, not admin fees, you can do that now in this 12B section that's called a broker service fee. So you would put the admin, not admin fee in this section B. The reason I call it an admin, not admin fee is because many, many years ago, this government oversight division called CFPB came in and they choose different industries to pick on, and they chose real estate to pick on and lending back in 2016. And that's when we went, for those of us who've been around for a while, we went from the HUD one to the ALTA statement, and then the CDs had to be disclosed several days before closing, and it felt like the world was crashing in on us, and now we're just very used to it. For anyone who's new, you have no idea what we're talking about, that there was ever anything different than what we do now, right? And I'm glad that you didn't have to go through that with us, because we really felt like everything was horrible. However, at that time, they came down on us in the real estate side hard for charging these admin fees. So we got around it, and we still do, by calling them something else. So it was additional commission or a flat fee or something. We cannot call them admin fees. I have seen settlement statements come back in the last couple of months where they are listed on the settlement statement as admin fees. So what I'm going to ask you to do when all of you are reviewing your settlement statements prior to closing is check. And if you charge the admin, not admin fee, and it actually says admin fee to KW United, send it back. Ask them to fix it. Okay, it needs to say anything else. I don't even care what it says. It doesn't matter what it says, as long as it doesn't have the word admin in it. Okay.
Where would it go again, Shannon?
Where does it go?
Yeah, where would you put it in
On the agreement right here, broker service fee.
service fee?
Mhm.
Okay, thank you.
Yep, absolutely. But make sure that you are catching it on the ALTA statements and send it back. If you have a title company that calls it an admin fee, this is to protect them and to protect you and to protect the office. Okay. Awesome. Questions about this? Do all of you hate it?
Why does it matter whether it's called an admin fee? What's the big deal with that word? I don't understand that.
CFPB forbids agents charging admin fees. And if they ever came back and audited, all of these fees would have to be paid back.
Got it. Okay.
And I'm sure they would fine people. So I want you to keep your money. Okay. Other questions? Okay, awesome. So there's another change that was made to the listing agreements, buyer agency agreements, that is 2 new documents, right? So there were 4 new documents provided, the 2 solar documents, and then there is a termination notice and agreement. And this stems from agents not being able to fire their sellers. Okay, we over time have been able to terminate buyer agency agreements, and we have never been able to terminate listing agreements. We've had to encourage our sellers when we've wanted to set them free to initiate that termination. But we on the brokerage side have never been able to say, I'm sorry, please go make someone else's life miserable, goodbye, right? So once we started digging into this, because it was very important that we have the ability, in my opinion, to do this, because they can fire us, why can't we fire them, right? We found out that really we weren't terminating any of the agreements properly. Any of you who are licensed in Maryland are familiar with the agency relationship and the brokerage relationship, right? The contractual relationship. And those both have to be terminated in Maryland. Well, they have to be terminated in Virginia too. We just weren't doing it. So now we're doing it. So that way we can fire our sellers. So at the bottom of this page, it says early termination. And the piece that's new here is that the seller will deliver written notice to terminate the agency agreement, the agency relationship between parties. Then the seller pays the early termination fee if there's one agreed to. And then there's a release. Okay, so let's talk about the difference between the agency relationship and the contractual relationship. An agency relationship is for personal services. Okay, you've agreed to represent them and their best interests, and it's more personal services. The example that I use is like your hairdresser. Okay, you have hired them for a personal service, and you can say at any time, I'm not coming back. It doesn't have to be mutual agreement, right? They can't say, oh no, I'm cutting your hair forever. You have to come back, right? If you have signed an agreement with that person that says you may charge my credit card for the next 25 years for the services, right? You can still say I'm not coming back, but they can charge your credit card because you haven't mutually agreed to end that. Okay, that's the contractual relationship. But the agency relationship is for that personal piece. So I can say, okay, I'm not coming back. Now, my friend that cuts my hair has been doing it since I was 16. So I probably can't actually end that relationship, but that's beside the point. So it might not have been a good example. However, you see how you don't need mutual agreement for that personal service, but when it's the contract, you do. Same thing with real estate. You can say, I'm no longer representing you anymore, but there are still contractual obligations that have to be worked out. So either party now can deliver notice. Now we have a document that's in this packet that I will show you, where if we're on the listing side, we're always going to use the documents that are provided to us. Okay, that's notice with a capital N. That means there's a document that we have to provide. The seller, on the other hand, can ask us for the document and we'll give it to them. They can fill it out and deliver it back, or they can send an email. And that is considered delivering notice as long as they do it to the brokerage email address that's provided on page 1 of our agency agreements. So if you're in Kingstown, it's kingstownrealtygroup@gmail.com. And if you're in Falls Church, it's kwfallschurch@gmail.com. Okay, those are the brokerage registered email addresses where notices get delivered. That's what goes on page 1 of your agency agreements. Once the notice is delivered, then it's mutual agreement to terminate the rest. And we'll go over those documents when we get to them. Okay, so I know you'll have more questions, and when I get to the documents, it will make more sense. We did add in the seller duty section and the broker duty section just a couple of clarifying things, mostly in the seller duty section right here for 26, just so that it's clear that the broker can terminate the agreement under certain circumstances. So it's basically breach of contract, right? If the seller's not cooperating, we can't just change our mind, right? And decide, the list price isn't high enough for our time, right? Like they actually have to be in a breach of contract status for us to terminate. So the seller duties, we just clarified a little bit. In most cases, you're not going to need this, but when you do, it's going to be important that we added it, okay? And we added a definition section at the end so that the agency relationship and the brokerage relationship, because now we have those two pieces that we have to terminate, we're clear. And a section for the solar panel addendum to the listing agreement, if it's attached, to be there.
Shannon, before you leave
Yes.
that paragraph 31, it looks like there's a typo. The following forms, if ratified and attached, shouldn't it say and?
Yes, and so they may have caught that before these go into the library, and I'll make sure. There's also a typo on one of the page numbers. So yes, I will. Good catch. I will make sure that they caught that.
I vote that Andy Stevens has to review all contracts before they're
Right.
out so that he can check the grammar and the spelling, because he's so
Yes.
good at that.
I'll
Yes.
keep my mouth shut now.
No, please don't. We need a proofreader.
Andy
All
must be a C.
Yeah. All right.
I usually get a higher grade than that.
A plus on my.
All right, so now we have the buyer agency agreement. The buyer agency agreement has a couple of additional changes than what we did in the listing agreement. And just another reminder, all of the changes to these agency agreements are carried through for all agency agreements. So, you know, if it applies to land, it went in that agreement. If it applies to the to a lease or tenant agreement, it went into that. So I didn't pull all of those documents to show you because you didn't need to sit with me all day to review everything, but it will carry over if it applies to that agreement. So the first change I want to show you here is purpose. So we moved purpose to the first page. Now, I don't know, I saw Alex was on here earlier. I don't know if he still is, but he's going to be really happy with this because when I have taught this class, the contracts class, I have always taught to put something very specific in the purpose. Who remembers what I say to put in the purpose? Who wants to say? Megan? You wanna say?
Residential real estate in Virginia.
Yeah, residential property in Virginia. That's right.
That's-
Residential property in Virginia. And the reason for that was because this agreement never actually said it was for Virginia. And it drove me nuts because it said it was governed by the laws of Virginia and these things. And I'm like, holy moly, right? I needed it to specify Virginia. And I wanted it to be very vague because I don't want you to be pigeonholed into, you know, a townhouse in Falls Church when they want to go buy a single family home in Woodbridge, okay? This line is also for where if you have a client who only wants you to help them with a specific property, you put the address of that specific property, okay? But we updated it so that it actually says that it's a property in Virginia. So now you don't have to put residential property in Virginia. You can just put residential or land or whatever it is, okay? And the line is long. Because before, this is why I know Alex is going to be very happy. The line was like this long and you couldn't fit much in DocuSign. So we had to abbreviate. The term and termination paragraph is updated and it looks a lot longer than it used to. And it's for two reasons. One, we added the 90-day disclosure, but two, our listing agreement has always said that if you go under contract before the expiration of this agreement, that it automatically extends until closing. But our buyer agreement never said that. We just assumed that the buyer agreement said that, but it never actually said that. So we fixed that and added the language that if you go under contract and this expires, your buyer agreement automatically extends. So in all the times I read this document, I still miss things. And yes, that's recorded. So you can go back and watch that over and over again for any of you that want to hear me say that I did something wrong. The buyer's duties section, we did update again just a little bit so that we would have the ability to terminate. It's not going to matter to you, hopefully, in any circumstance. Hopefully, you're just going to get everybody to closing and it's going to be wonderful. And now we come to the reason for all of the compensation sections to change. The buyer agency agreement, and how all of the lovelies like to write stories about how they're going to get paid that don't always mean anything. So the current version says buyer will pay compensation in the amount of blank to broker if buyer enters into a contract to acquire real property, blah, 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 blah. Okay. So the things that I would see in this line, you can only imagine. The most common thing that I would see is per MLS, okay? Per MLS does not work because the MLS is not part of this agreement. What's offered in the MLS is offered by someone who is not a party to this agreement. So we can't keep them on the hook to pay us something because they actually didn't agree to pay us anything, right? And what happens if the buyer buys something that's not in the MLS? Then what? Then we're not actually allowed to collect the funds because what we said was we're only collecting what is offered in the MLS. So if they go buy something from the builder and the builder didn't list it in the MLS, then we're not legally allowed to collect that money. Okay, so that was a challenge. I would also see things like a percentage plus the admin, not admin fee. Okay, so let's say they would put 2% plus $3.95, and the offering in the MLS was 3%. Well, the agent would collect on the settlement statement the 3% and charge the client $3.95. Well, that wasn't okay either, because what this paragraph says is that it's 2% plus $3.95, and that anything offered on behalf of the buyer paid by someone else covers this fee. So really, the offering in the MLS covered the $3.95. So they weren't allowed to charge the $3.95. So that was a challenge. I would also see things like just a number and not the percentage. So if the agent was trying to charge 2.5% of the gross sale price, I would see 2.5. But 2.5 of what? Was it $2.5? Was it 2.5 what? Pennies? 2.5 pounds sterling? Like, I don't know, right? What was it? 2.5 what? So it wouldn't actually say 2.5% of gross sale price. It didn't actually say that. So that was a challenge. So we cleaned it up. Oh, the other one that we would see that wasn't enforceable was the or statement. It would say 2%, the greater of 2% or what's offered in the MLS. Well, who gets to decide? And what if it's not offered in the MLS? And what happens with, you know, who picks in the or statement, right? Because if you're trying to charge the buyer wants the least amount, right? And the agent wants the highest amount. So then who picks when it's an or statement? So that wasn't enforceable. So anyway, I could go on, but those were the top ones that I would see. So what we have here is simply, are you charging a percentage of the gross sale price or a flat fee? And what goes here is the minimum you're willing to work for. And this is consistent throughout. You don't get to pick and choose what buyer you're charging a different fee to. If it's the same service, it's the same fee. And that is not Shannon Lauderstein's rule. That is not KW United's rule. That is fair housing. And that is equal housing opportunity. That is not our rules, okay? So if you have different services that you offer, then absolutely you can charge a different fee. Mostly, you will have different services on listings, not buyers. Buyers, you're generally providing the same service. But if it's a listing, it's going to be, there's an opportunity there where sellers are going to try to negotiate you, and you will need to have different services laid out so that when they try to negotiate you, you know what service can go out the window for what price, okay? We've added a place for that broker
I have a
service.
question. This is Veronica.
If you have the broker service fee, the admin, not admin fee, this is where it would go. And again, don't let it be called an admin fee on your Alta statement.
Hey, Shanna, can you hear me?
Oh, yes. Hi, Veronica.
Hi, just a quickly question.
Mhm.
What happens if I put 2.5% as a percentage of the sales price, right? And then I go to Brett MLS and the listing agent puts only 2%. And the buyer and the buyer, you know, of course, I need to disclose to the agent, to the buyer that, you know, that house, it will only give me 2%. And let's say the buyer said, no, I'm not willing to pay the difference. What happens if this happens? So
Okay.
what do we need to do?
Yep. So that's a great question. So that's why I say the fee that you charge in your business has to be the minimum that you're willing to work for. So in this section, if your fee for your buyer agent services is 2.5%, then this is a conversation that you're having with the buyers before they sign the agreement. And you're explaining what happens in that case so that they know up front, not just when you've shown the property and they want to make an offer, they know up front. If you're not willing to charge your clients the difference and you're willing to just take a lower fee, then you decide for your business what you're willing to do. And that number is what goes in here. So I know agents who are willing to put in a lower number because they are at a point in their career where they're willing to take that risk. I also know that I have spoken to someone earlier this week who used to use per MLS and didn't realize the impact of that until we went over the forms update, does a ton of business and is now changing it to say a flat fee because there is a minimum that it's worth working for. This is not a volunteer opportunity for all of you. We have plenty of volunteer opportunities that we can get you involved in, and this is not one of them. This is how you take care of your families, and this is how you support yourselves, and this is how you get to the other goals in your life. And so I encourage you to know your value and be able to communicate your value to the buyers for that. And if you feel that what's being offered is going to be less, then maybe you adjust that for your business practice. And there will be certain circumstances where you have to adjust what your fee is. And you have to think about that and whether you're going to adjust your fee. And at the same time, is that a duplicatable circumstance? Is it simply that they just don't want to pay the difference? Or is there a circumstance where they can't, like it's VA financing and they're not allowed to pay the difference? In that case, that's fine because they're not allowed to pay the difference. You can't charge them. But you really have to think about how is that going to impact your overall business? And did you have the conversation up front to set the expectation?
Totally understand. And what happened if, you know, let's say what scenario we put 2% and then a Bright MLS says 2.5%. And on the settlement, you know, they will see, the buyer will see that it's not 2%, but 2.5%. How, you know, how it works? Do they still pay 2.5% if a bright MLS says 2.5%, or how does it work?
Yeah, so again, this is about explaining the document to your clients before they sign it, because what this says is that your minimum fee would be, in this example, is 2%. And the pre-printed language says that the buyer is authorizing you to collect anything that is offered that is above what your fee is listed.
Okay, okay, perfect. Thank you so much.
You're welcome. All right, so we have broker service fee. And then we also have, at the end of this agreement, we have had for a couple of years a bold print disclosure for the buyers that says, hey, don't go to new home construction without us. Like, just don't, is pretty much what it says. We added another disclosure, and it's here under property types. And it's saying, hey, buyer, listen, this agreement applies to every property type during our agreement. So it says the buyer agrees to the terms of this paragraph when entering into any contract for any type of real property, including but not limited to new home construction, off-market listings, properties for sale by owner, and the like. Okay, so if it fits the purpose, right, and they enter into a contract, this applies. So we're just trying to remind them, don't go off on your own and be rogue about things. Like, you hired us, let us do our job, because you're going to pay us. The buyer default paragraph, we updated the couple of items like we did in the seller one. Definitions paragraph we have added. And the page numbers, Andy, I caught the page number issue, so hopefully it gets fixed before July 1st. Okay, and that's it on this one. The only other agency agreement item that I want to point out is on the listing agreement for rentals. Today, your version says that if a tenant purchases the home that they have rented, that the landlord gets to pay the listing agent a fee if it's negotiated. Okay, so you take a listing that's a rental, and there's a place that says tenant purchase, and it says if the tenant purchases the property within 60 days of the end of the lease term or move out, that the landlord will pay the listing agent blank, and it's negotiable. And some people put 6%, 3%, 1%, $5. I don't know. Some of it's ridiculous and some of it is not. We removed that line, and we removed it for a number of reasons. We encourage our agents, all agents, to stay in touch with their clients. Okay, you don't just drop them as soon as your agency relationship ends. Now it becomes a client customer relationship that you're trying to maintain with them for time, but you no longer have the agency relationship. If the tenant wants to purchase the property, unless there was an agreement put in place when the tenant came in to lease the property that said it was a lease option to purchase or something other than that, then the landlord really wasn't procuring costs. And that's kind of why that was in there to begin with. Also, they're not doing anything necessarily to help facilitate the purchase. They could, in which case you enter into a listing agreement so that there is a true agency and contractual relationship so that it's clear what the roles are. It could cause the landlord to have to pay extra money because maybe they hire somebody else to facilitate that, but then the listing agent from the rental side puts their hand out and says, oh, you owe me money. Sorry, you owe me money too. So it caused a lot of issues. And so we took it out so that if the landlord's agent is actually involved in the transaction that becomes a purchase transaction, they just have to sign a new agency agreement that would be as a listing agent. And then they can collect money and they can do whatever it is that they've agreed to do. Okay, so that's the only other change on that. Now, brokerage representation agreement release, and then there is a notice here next. Okay, so I'm actually going to start with the notice and go backwards. The notice is the document we talked about where either party delivers to the other and says, hey, I'm not representing you anymore, or if you're the client, I don't want you representing me anymore. Okay, so the agency part of the relationship is terminated. It's unilateral, and it says that we're terminating this. You don't get to have a discussion about it. I'm telling you, we're done. Okay, so if it's the brokerage delivering it, we're always using this document. If it's the client, they can ask for it and you give it to them and they fill it out and send it back. Okay, it's very simple. This document here is the release of brokerage representation. So this is where everybody has to sign, saying that they agree to the full brokerage representation agreement, the contractual relationship ending. And so it has to be filled out saying that the agreement that was fully executed, right, ratified on a certain day, is done. The notice was provided on a certain day, right, that other document. Was there a fee? Right, that goes in here. The important part for listings is this. Right now, we have a listing amendment document that says at the bottom, termination/cancellation. And that's what everyone has been using right now to terminate a listing agreement. I presented that document to have a change so that it would be an agency agreement amendment. So you could adjust a buyer agency agreement. So like change the expiration date of a buyer agency agreement or some other term in it. And that document was sent back to the committee because of formatting. Okay, they were great with the content. They didn't like the formatting. And I take full responsibility for not explaining the implication of not having that document approved with these other two documents, because there is now confusion and we're trying to get that document approved for a mid-cycle update so that we don't have the confusion for a full 6 months. What the confusion is this, that listing amendment still looks exactly the same. So at the bottom, it has a box for termination/cancellation of your listing. Do not use that if you're terminating or canceling your listing. If you use it, you still have to have these other documents, but you don't have to use it because right here on number 9, it says the brokerage agreement is terminated effective blank. And if the property is listed in the MLS, the broker will cancel the listing effective as of the date within this paragraph. Okay, so you don't need that listing amendment document to be able to terminate it in the MLS. Okay, so it's going to be a little confusing because that other document is still out there with the verbiage. We actually took the verbiage off of that document when we presented it, and then it was not approved. And so we had to put it back because we can't make an update without the board's approval. Okay. Questions on these two documents? Okay, awesome. The last two documents that I want to just share with you that you will see updated in your forms library that aren't NVAR related are the KW United and Universal Title ABA, and another document that is another affiliated business partnership disclosure. It's not really an affiliated business arrangement, as required by RESPA, the same way that the universal title one is. The universal title ABA is required by RESPA because we have a joint venture with universal title. And what that means is that we have, the market centers have ownership with universal title. And because of that, the market center has a financial benefit to clients using universal title. And even if the clients don't use universal title, someone else does, right? And agents have a benefit, sometimes a separate benefit, but ultimately all of our agents have a benefit because the market center has a financial benefit. And universal title may teach classes, they may sponsor something. There's ways that every agent in the market centers will benefit from that business partnership. So we have to have a very specific disclosure that RESPA requires. And it's every sale or buyer that we have to have that disclosure. And it's in the package with your listing agreement or your buyer agency agreement. Again, it doesn't matter who they use, but we have to disclose that there is that business arrangement. The second document that's a new document that you will see is a document that is disclosing partnerships that we have with the different vendors, the different business partners that we have brought in to provide different services for you and your clients. Because there are different financial benefits to the market center or to the agents, there are different disclosures that have to be made. And these disclosures are required regardless of whether it's a sale or a rental or a commercial deal or anything else. The disclosures are required. Some of it has certain RESPA language that's required because of the way that the partnerships are set up. Some of the language is required because of the way that we have the referrals being paid, right? So we've shared about like Dan's Van Lines and referral opportunities with Dan's Van Lines. Those disclosures are required by NAR and the Code of Ethics, okay? So what we did was we put all of these together in a second document so that we make sure that everybody's covered and we have those disclosures in place. It's, again, no requirement to use any of these. So we have Patriot Insurance, we have America's Preferred Home Warranty, we have Dan's Van Lines, we have CMG, Mortgage. All of these different partners that we have will be listed and the required disclosures for them on these two documents. Obviously, CMG doesn't apply to a rental, but maybe you can turn a renter into a buyer when they get that in their head, like, oh, hey, mortgage, maybe I should look at it. So anyway, I just wanted to bring that to your attention. You'll see the documents in the forms libraries soon, and those will be added as a required checklist spot for you in Command, and they'll automatically populate for you in your rooms as well. Okay, but since we're doing forms updates, we wanted to make sure that you knew about them.
Sorry, Shannon. What will be the name of this form?
Well, the universal title one will still be the ABA.
Yes.
And then the other one, maybe it'll be something about, KW United partnership disclosure or something like that, so that you'll know that it's something that has to go with everything.
Okay, thank you.
But I'm not sure yet what the title is on that one. Okay, you guys made it. It's 12:40. Look at that. You guys are rock stars. All right, so who has questions, comments? Do you all hate me for all of these updates? Hi, Marty.
Hey, quick question about the tenant agency agreement where you were talking about the buyer agency agreement with the additional responsibilities so that if the buyer went rogue, they would know they still have a responsibility to you. What about tenants that you're signed with and go military by owner or go off on Zillow and do their own thing. I'm actually, just because of this situation, I have determined I am never doing another rental. But I'm just wondering if that form has been updated also for tenants.
Yeah, I believe it is. I'm gonna pull it up specifically and let you know. So I'm just going to that document real quick right now.
Okay.
And I can answer any other questions while I'm trying to find that one.
I've got a real quick one.
Yeah.
When are we going to a due diligence contract?
When we moved to North Carolina.
Such a better contract. Right, Lily? She's like, no. You don't have to worry about all these dates.
The North Carolina
contingencies.
people are 10 years behind Virginia. It's helped me so much to have come from a very restrictive state to a state that just wants to protect the agent's commission and the brokerage. That's all they're about.
We were a contingency state first, and we went to due diligence. We had the contingencies, every one of them, just like we do here, and got rid of them.
That was crazy. People are so mad about how long due diligence is now.
Well, I mean, that's a negotiating technique.
Yeah, but you can't get home inspectors. You can't get inspections. You can't get surveys. We don't have enough people. We need people to move here. Anybody need jobs, please move. Don't come if you're retired, only if you're going to work.
Well, and I hear so many people in North Carolina complain that it's prohibitive for like first-time buyers or buyers without money, because the due diligence, when you have to put up money, and then it just goes away, right? Like if you want to void, you don't get the money back. You have the due diligence money, and then you have the earnest money. So your due diligence money, if you void for any reason, your due diligence money is gone. So people that are tight on money, it doesn't work for them because they can't afford to lose that money. So I'm hearing a lot. I have friends that live in North Carolina.
Well, you don't have to do due diligence money.
Well,
they wanna
right
win.
now you do.
Yeah.
Right now you
It's
do.
very competitive.
But
here.
so why should a seller take their home off the market for a buyer that decides they want to walk away?
No, I know, but
Without
that's what I'm
losing
saying is,
for
like,
it.
for the competitive nature
Yeah.
right now, it's very hard in
Yeah.
that contract. It's very hard in that.
Yeah,
contract.
as a listing agent, I loved due diligence money.
Oh, I'm sure.
People get $10,000 and $20,000 due diligence checks.
Oh,
and
now that's just crazy.
a
Yeah.
lot of lawsuits.
Yeah,
Yeah.
that's crazy.
Yeah. All right. Anybody have, tell me something you like about the changes. Anybody like anything that we changed?
There was one that I remember you said, I said, oh, this is a brilliant change, but now I don't remember what it was. Sorry.
Andy.
Well, I don't have it on the screen in front of me, but I do have a question.
Okay.
Occasionally there's a buyer who doesn't want to get married and just wants to commit to having me represent them on one particular house.
Yes.
What I've been doing is putting in a sentence at those few blank lines at the end saying this applies only to such and such an address. Would you rather I do that or fill in that paragraph that line where it says type of property that we're searching for?
Yeah, just put it under the purpose, put the address under that purpose in section 3, and you'll be covered.
Okay, thanks.
All right, who else? Questions or ahas of something wonderful?
I like the HOA and condo combination now.
Okay, well, I didn't do that. No, I'm kidding.
Whoever did it, I like it.
I do like that it's now one paragraph. I do
Yeah.
like that.
I like the solar.
Yeah, that was definitely a big gap in our contract. Is anybody mad at me about the commission paragraphs? Because I definitely take full responsibility for that. All right. Hey, if you guys don't have anything else, I'm gonna let you go. And it's 12:46. Thank you all for being here. This is recorded. I will put it on the KW United YouTube channel. So if you would like to rewatch and re-listen anytime, you may, because it will be there forever. Well, until we change the documents again. So, but of course, with the internet, everything's there forever. I'm sure you could find it. So, all right. Have a wonderful Friday and a wonderful weekend. And I will talk to you all later.
Thanks, Shannon.
Thanks, Shannon.
Thanks, Shannon.
Thank you.
Thanks, Shannon.